Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes. Hi everyone, my name is Sherine Abdi.
And I'm Princewill.
And today we'll be talking to you about dispute resolution methods.
So there's various ways you can resolve a family law matter. And if you've just recently separated, you're probably thinking, what next? What do I do? How do I go about this? Well, you're in luck. That's what we're going to be talking about today. And I'm just going to list off the dispute resolution processes very quickly. And we want you to kind of see that as a continuum. And I'm just going to the list, okay? So there's negotiation, mediation, arbitration, collaborative family law, parenting coordination, and litigation.
So there's a lot.
Yeah. So that's how many processes? That's about 6 methods, right? Mm-hmm. And more often than not, when you're going through your matter, you might be using a combination of some or all of them.
100%.
Okay. So let's start off with negotiation. At our firm, we generally like to start every matter with negotiations, right?
Oh, 100%. I think that's the starting point for a lot of people. I think a lot of people come to us, they're a little confused about how actually the process starts. So they're wondering, okay, do you reach out to them? Like, how does this kind of, how do we really start or really get the ball rolling?
Exactly.
And our first step is to negotiate. It's to send out that introduction letter, letting them know what our goal is for the file.
Exactly. And I mean, amicable negotiations is usually the first step, as Sherine said. And, ideally, if we have the other side get a lawyer, then, lawyer to lawyer negotiations could really more often than not actually resolve the matter, or it could really help in narrowing the issue.
Yes. So it's always so fun when you're dealing with a self-represented party, because sometimes it's the legal issues that you kind of have to explain to a party who's really not understanding, or it's much easier to negotiate with another lawyer on the file, in my opinion.
Yes. And there's always that fear for me if I'm dealing with parties that are amicable and I'm negotiating on behalf of my client, but I don't want the other side to get the impression that I'm their lawyer as well, and they're thinking I'm acting in a joint capacity, because we really can't do that, right? There's a conflict there.
Yes.
So that's usually our step 1. We hope things get settled by negotiation. If it doesn't, then, obviously, depending on how things go. Now, there's times when I've seen lawyers the first hello is an application, is a court process.
Those are my favorite.
Yeah. And it's, and I talked about sort of this, the way we view it at our firm is it's sort of this continuum. Like you start trying to negotiate, which we try with the lower processes before escalating all the way to litigation. And we will talk about litigation in more detail, but the problem with going to the end of that spectrum is you're almost killing any goodwill along the way. Having said that, there's times where that's appropriate. But for the bulk of my files, I always tell clients it's easier to catch bees, with honey. So
Your famous quote.
Yeah. And it's it's inexpensive. I shouldn't say inexpensive, because of course it's relative. I would not want to spend $1 on legal fees if I don't have to, but it's more cost effective.
Yeah. That's like the biggest selling point. And at some point in every process, you're going to have to put on a negotiation at some point. There's always it's never just litigation and then you pop out an order.
Yeah.
You're going to have to negotiate along the way with whatever process that you do.
Yeah.
But yeah, I find that like the best process is really if you're amicable, and hopefully negotiation does work out from you for the starting point.
And at least settle some issues, if not all, and then we can take the next issues that don't get settled between the parties or the lawyers to mediation.
Yeah, the biggest benefit, I think, to negotiation is you actually getting an opportunity to hear the other side's position.
Yes.
So at some point, you're at least have more clarity as opposed to, like you said, starting with their first hello as a court application. So, I mean, granted, you would get their position as well, but there is no room for, I guess you would see what the room for improvement is, what the most contentious issues are, what issues can be narrowed, and things like that.
Without being so polarized, right? Which is what happens in litigation. So mediation is another process that is available to parties that are trying to resolve their disputes. And with mediation, I think that's where kind of people mix it up with negotiation. So with mediation, you have a neutral third party whose role is to facilitate a settlement for the parties. That's really what it is in its simplest form.
Yep, it's one of the processes that I prefer the most because it's very, I think it's more informal, but it's also impactful for the parties. And impactful, I mean, sometimes it helps keep families intact. For example, it's kind of more of an informal process. You get an opportunity to really explore kind of the impediment that you guys have. And it's more of a informal setting. So you can actually explain, why this particular parenting schedule doesn't work for you or your emotional feelings. Sometimes with lawyers, it's a little difficult to kind of have the time to explain your client's position from that perspective.
Yeah, and because the judges don't have the resources to deal with that. And by resources, I just mean sometimes they just don't have the time. Yeah. Like their dockets are very full. And, if you're unfortunate enough to be in a trial setting, the judge doesn't care to understand, or I shouldn't put it that way. It's not their job to sit down there and really understand in that kind of informal sense way. They just want to hear the legal positions and then they go make a decision that they see best, right? Given the facts that both sides have presented. In a conference, the judges are a little bit more lenient in terms of wanting to understand each party's position. But even then, it's not the same. They don't have the same amount of time to give to your matter. And I think for me, what I like more about mediation is it takes away a lot of the formalities of court, right? Yep. So you can, and I'm a mediator myself, and I'm able to design every process that we're working on. So it's not a one size fit all. So when you're in court, it's case conferences. You have to file your brief within X number of days and you have to confirm it. And
it's a very procedural, formal process.
Yeah. And your matter could fail just because a procedural step was not observed. But with mediation, the mediator can decide to design or chooses to design how they want the process to go. So it could be no briefs are necessary, and that would be great because sometimes you don't really need those briefs, especially if the parties have been in court already. You can ask for a couple of their court paperwork and you get the picture. The mediator can get to sit down and really spend time with the parties to understand the emotions behind things.
And they can do focused issues. So, for example, on your first session, you might only deal with the parenting schedule. And then on your next session, you could deal with the decision-making responsibilities. So it's really catered to the parties. And I think it's so beneficial especially if the parties are close. And they just need to pan out some of those nitty-gritty details, and they need that neutral person to step in, and maybe litigation is probably not the most appropriate.
If it's not a clear-cut legal issue where you're clearly, and it's usually very rare that something is just so black and white. If it's not a clear-cut legal issue, then you probably would be better served with mediation because you want someone that would really take the time to understand it, right? So the formalities out, is gone. And I noticed that with a lot of people as well, they just you just need assistance in facilitating that conversation. And depending, and I know with Sherine and I as well, depending on the issues we're dealing with, we can shop for the mediator that would fit sort of that style,
I think
right?
that's the most important thing is, not only does it make the parties feel more comfortable that they're not, sometimes, court is not for everybody. Mm-hmm. So it makes them feel a little more comfortable in that setting, but also is that you actually get to find mediators that are specific to your needs. So if I have a lot of property issues or very specific issues that are a little more legally complex, I prefer family law lawyers that are also mediators to go in and help someone who's a little more keen and understanding on the law. Mm-hmm. And then oftentimes there are mediators who have over 20 years of experience dealing with primarily parenting issues. So you can pick and choose.
Yes, as opposed to court where it's just the luck of the draw. You don't know who you're dealing with. And yeah, I mean, okay, so with all the great things there is to say about mediation, I think the only drawback is that the parties are there willingly, and one party can just withdraw from the process and all of that conversation just ends. Right?
Yeah, and there also isn't a distinction between open and closed mediation.
Well, I don't know why anyone would want to do an open mediation. I don't. I want to be able to facilitate. I see my role as facilitating a conversation. I like to give my input because from years of working within the court system, I have a fairly good idea what each party may obtain if they took the matter to litigation. So I would give my input, but I really don't want to have to be called as a witness or to have to write a report to a court. Almost feeling like I have to tell on someone. You want people to be open and have a great
free to come to those negotiations, free to come to those settlement terms.
Yeah.
And I think another important thing is if you have a more contentious relationship with the other party, there's something called shuttle mediation. And Andrew, do you want to kind of explain briefly what that is?
Yeah, so shuttle mediation is where we can have both parties not being in the same room. So back in the pre-COVID days where we actually could have mediation at our offices, it would be the parties and myself sitting in the boardroom and then we would caucus from time to time, right? So if I think, so we're having a conversation, everyone's, airing their positions and things like that in a very open and respectful way. And the kind of way you would have a conversation when you have a third party that's trying to facilitate some kind of settlement. And it's great, but when things start to look like they want to break down or when you think you can make progress by sort of separating the parties a little bit, then we do that. But shuttle is just unique in that both parties from beginning to the end of the negotiations are in separate rooms. Mm-hmm. So I don't have everyone on the table and you talk to each party separately, and it's very effective for, even cases where there's abuse,
a power imbalance. Yes. Yeah. I find that, the simplest way to put it is the mediator shuffling back and forth between the two parties.
Yeah. So that's really what it is. And it's very effective. And sometimes it's even when there's no power imbalance, but you find that one party wants to rehash too much of what happened during the relationship, or both parties are very passionate about sort of the details.
Yeah.
You might want to keep them apart because that could just derail the negotiations.
That's an impediment, of course.
It would derail the negotiations because they're just so focused on blaming people, and which is, it's part for course, it's part of the process with, dealing with the separation. There's obviously going to be some sort of blame, but just some people handle it a little bit better. So if it looks like it's going to derail negotiations, then yeah, Sherine's right. Shuttle mediation is fantastic.
Yeah, if they have a long contentious, or if I'm already on the file with and there's already been significant contentious issues, then sometimes I actually just prefer from the onset, I'd have that conversation with my client. Obviously there's a domestic screening that takes place before a mediation just to confer whether or not it's appropriate to proceed with both parties being all together or separate. But I let them know, do you feel more comfortable? And sometimes sometimes people actually just don't want to see the other partner.
They don't want to be sitting in the same room as them. Yeah.
Yeah. They want to settle. And I think that's the beauty of it. They want to settle, but they don't want to necessarily be in the same room or in the same kind of mindset. And I think that's still a great process.
Yeah. And obviously with technology and with everything being done virtually, these days there's all sorts of modified shuttle mediations, right?
Yeah,
so for
mostly
starters,
conducted by Zoom.
you're on Zoom, you're not in the same place, so that there's that first layer of protection. You can ask the party that feels uncomfortable to maybe turn off their cameras, for example, so that they can be part of the conversation, but they're not having to face the other party. Sometimes it's fear, and sometimes they just don't want to see the other person.
And sometimes they're nervous.
Yeah. So that's mediation. Let's jump quickly to arbitration.
Yes.
I like arbitration because
I love arbitration.
I guess it's just you picking your judge. That's really what it is. It's binding. It's quick. It's everything that you would want court to be.
Yeah, think of it as a more informal trial. So if you actually do proceed to the arbitration process, you know that you're going to get that final decision. And sometimes people, when you're having contentious issues and you're not really seeing an impasse, that's probably the most vital and, the most biggest benefit to actually going to arbitration is that, even if it doesn't work in your favor, you're getting that binding authority in the less amount of time that you would have in the litigation process, and with probably a lot less in legal fees.
Yeah. So I think I want to put some context here. So you're talking more about mediation arbitration, right?
Yes.
So you could have just arbitration as its own standalone process where you just come in. Sherine and I usually like to have, I don't like just mediation. I like to have mediation and arbitration as a combination of processes.
Yeah.
Right?
And for those of you that are unaware, it's the same person that acts as both. So basically the simplest way is the mediation will take place. They have their mediator hat on and they use that role. And where we see an impasse, we would bring a motion for an arbitration on a specific issue or on multiple issues. And then that person would now not be that neutral third party, would be that person making the binding decision and the arbitrator, and therefore make the binding decision.
I know that makes people nervous and they think, well, isn't there a conflict? I mean, there is some sort of conflict, but your mediator knows what the law is. So when they're acting in the capacity as mediator, they're not trying to impose a decision. They're just trying to help the parties reach a settlement. And if that's impossible, then they make the decision based on legal principles, right? Yeah. So it's actually better for you because then if there's no settlement, you're not dealing with the process is already ongoing. The mediator or / arbitrator now already knows a lot about knows the facts of your case probably in a more in-depth way than, even a trial judge would probably know.
Yeah, because you have that opportunity to have that one-on-one with the mediator, especially if you're doing shuttle mediation. The mediator's in your room with your counsel, and then shuffles back and forth. So you're getting an opportunity to talk to them and really dish out why you feel the way you feel, and not just the emotional, but the legal ramifications of the issues that need to take place. Have
you found that, and I know I have, the answer for me is yes, that for a lot of cases where we sign up for mediation arbitration, I find that we rarely go to arbitration. We always settle at the mediation.
It is actually very, I find that with my practice as well, that I've actually only had to use the arbitration process very few times. Yeah. But it mostly settles at the mediation. Yeah. And I think it's mainly because even the mediator will tell you, okay, this is kind of what I'm leaning towards based on, they kind of let you know sometimes. And you can kind of get a gist of where you are in the process and how you would fare in an arbitration. Yeah. So I think that's helpful to settle at that time too.
Yeah, I guess so. But you're right. So I really like to sign up for mediation arbitration. I don't like I feel like sometimes when we don't have that, idea or fear of arbitration, someone could just waste your time, drag the matter out for however long they want. I just like the fact that at some point we can decide, we can agree to disagree, and for better or worse, right? I would be the first to say maybe my position is not necessarily the most reasonable one. My client might not be the most reasonable one, but their position is their position. And I would be a zealous advocate because that's my job. And if, if the arbitrator thinks otherwise and it's from a legal standpoint, absolutely. And, there's rights of appeal, right? So, I mean, you can appeal from the arbitrator's decision if you don't agree with it. Now, not just in a vacuum, not because you just don't agree with it or just because you don't like it. It's the same as a court order. It's the same that would happen if I disagree with a lawyer all to the point where we get to a trial and my client is so set in their belief. And now I'll preface this by saying we would not go as far as arbitration or as far as a trial if we didn't feel like we were on the right side of the law, right? Because everyone knows that it takes a toll on the parties. It's expensive. So if we're on the right side of the law and we strongly believe that, then we'll just, let it go and let a judge tell us, confirm that we're right or not. And obviously, if we don't like the decision, you don't like it. It is what it is. But at least there's finality and everybody can move on from it, right?
Yeah.
Okay, so collaborative family law.
Well, I'll let the collaborative lawyer here actually explain that process to you.
Yeah, so it's a very interesting and interesting a process for resolving your disputes. It's very effective, and it's not mediation. It's negotiation. It's probably closer to negotiation.
It's probably, from my perspective, and I think the easiest way to explain it is the most equal partnership in settling your issues to some extent. Like it's a very collaborative, a very intact way of settling your issues.
Yes. So the great thing with collaborative family law is we've looked at it and we say, well, as lawyers, for settlement focused lawyers like Sherine and myself, well, we want to start negotiating and things like that. But there's lawyers that could drag negotiations on, and you find that you could end up even you might as well have gone to litigation because they've dragged it on and just turned you. I mean,
whether it's for strategic reasons, like whether the delay serves them. Fair enough.
So the negotiation is just going nowhere. So with collaborative family law, you must have two lawyers. So that's the great thing. There's always two lawyers. Both lawyers have to be collaboratively trained, and both have to sign all the parties actually. So the clients and both lawyers, and that's the minimum number of people, two lawyers, and the parties have to sign an agreement. It's called a participation agreement. And the unique thing about collaborative family law is you agree at that point that if you're unable to reach a final agreement, that neither of the lawyers would represent the parties if it goes to litigation. That's what's so unique about collaborative family law because, one of the things, there's a lot of unique things, but with negotiations, if it breaks down, we'll take it to court. With mediation, it's the same thing. Doesn't work out, we go to court. Arbitration, if we find a problem with, the decision, if it's wrong on a question of law or it's not procedurally right or something, we can always proceed to appeal that arbitral award, as the same lawyers. But with collaborative family law, you can't do that.
But there's a pro and a con to that.
Yes. So I struggled with the con, which is I felt very concerned, or I feel very concerned about the fact that if it doesn't settle, then I can't represent the client.
Especially if you've gotten a very far way, and you're very familiar with the file, and now, you're not allowed to actually represent that person in litigation. And that's the concerning part, even both from your perspective and from a client's perspective.
Yeah, because for the client, it costs money when you have to switch lawyers, right? If you're changing lawyers, it's the new lawyer has to get caught up on the matter and things like that.
Especially if you love your lawyer.
But the good news in all of that is at a minimum of about 85% of collaborative cases settle within the collaborative process. And here's why: because a lot of times within the collaborative process, we work as a team. So I talked about the parties each having a lawyer and signing that participation agreement as the minimum. But more often than not, we have a family professional, so usually a therapist, a social worker, someone to take care of the mental health aspects of the parties. And then we have a financial neutral who is just a financial guru to work out all of the financial details. It's amazing the amount of things that we miss in every other family law process. I honestly think that this is the best way for every family, because there's always, like, if you think about it, your client might be disagreeing to a settlement. And the only reason why they might be doing that is because they haven't gotten over the fact that they were cheated on.
Yeah, it's that emotional connection. That's what I think collaborative is so unique and so special, especially when it comes to resolving family files. And I think the whole process of having someone in there, especially the therapist, and having someone to emotionally deal with a lot of that trauma, I think that is the most incredible part to me.
It is. When you're having, even when you're having the team meetings, so with lawyers, we get stuck in what's like, we're looking at things from, and with practice, you kind of learn, and I know it was a lot of, I say collaborative, family law, brings out the better person in me, because when I'm dealing with in a non-collaborative file, all I'm thinking about is my client and the law and how the facts fit within the law. And I'm very brutally honest with my clients. If something doesn't fly, I'm going to tell them. So it's just that laser focus. Yeah, I'm thinking the law, my client, what's the best interest? What does the law say about this? Now, when you're in a collaborative process, you try to also consider the other party's position.
Yeah, it's a holistic approach.
Yes, where are they coming from? And when we get into lawyer mode, you have that social worker or therapist there that is looking at the parties and can see that they're starting to get overwhelmed and would call for a break. Because how many times you and I could go at this for days, like even with mediation,
even the financial expert part, I think having some neutral expert there that's actually there for both parties is such a critical part of the collaborative process, and I think it's so useful.
It is. And do you know how many times...
I wish all of my files could be collaborative, by the way.
That's amazing. No, but do you know how many times people don't hear what we're saying because it's coming from a lawyer? So simple example. I work the spousal support advisory guidelines all day, every day. I know the laws. I know what should be, where I can work the numbers. If I come up with a spousal support amount, you would be surprised at the amount of resistance I would get from the other side. If the financial neutral does the same, and not just the other side, even my client. When I tell my client, okay, maybe you need to pay $5,000 a month in spousal support because this is what the numbers say. If they hear this differently, when it comes from a financial professional, that would show them, and okay, fine, it's $5,000 a month, but here's a budget, because the financial neutral would work on a budget for them, right? Mm-hmm. So if they have investment, some of them can actually offer investment advice and things like that. So they deal with it in a much more holistic way. You're not getting that
from the traditional perspective.
Yeah. So I think it's very helpful. Obviously, not every file needs this, but I found that more often than not, when you have lawyers, you have mental health professionals, and, you have that financial neutral, all part of a file, all committed to settling, and all having decided that if this doesn't settle, none of the parties can take this to court. You're not going to take the therapist's notes to court. You'll be surprised how motivated people are to settle.
Yeah, I think when you're committed to such a process, I think that's the key, is that you have to be committed to settling the process. And it is a process. Every process is a process. But I think also that's what helps people settle, because no one wants to have to now go ahead and retain a new lawyer, review the file, and start from, I wouldn't say scratch, because obviously the financial piece and some of the financial disclosure I would assume would be what I would hope at some point that some of that would have been taken care of, but it's still not the greatest. So it makes sense why it has a high resolution rate.
Absolutely, yeah. And it's just, as you said, even, I don't know. I'm going to stop with collaborative because we almost sound like we're selling everyone on the collaborative process, but like everything else, it's not for everyone. But I think it does have its pros. The cons is sometimes it could be viewed as expensive, because then you're having to pay for professionals. it looks that way. It's the same concern with mediation as well, or arbitration. It looks expensive.
Especially from the onset, it looks expensive.
We can tell you that when it's a fraction, whatever it is you think you're paying, it would be a fraction of the cost if we had to take your matter all the way to litigation. The only difference is we can do this and bang things out with these processes within 6 months. Or, you know, we could take you to court and you spread the payments over the course of 2 years.
Yeah.
Okay, so parenting coordination. So that's another process. So I'm going to let Sherine lead with that one because I feel like you must be bored hearing me speak after.
No, never. Parenting coordination is usually reserved for parties who have very specific scheduling concerns, day-to-day parenting concerns that actually just need a little more finessing, I would call it. Mm-hmm. So they need to sit down with the parties. And for example, most parenting coordinators, we call them PCs, also do mediation work. So they're a little more understanding in that they probably utilize the same skills. But for parenting coordination, for example, the way you would use it is, you know, pickups at daycare are not being adhered to. You know, there's contentious issues. So, okay, where else can you have pickups if not at the daycare? And how to limit that conflict between the parties. So they're going to take more of a child-focused approach, look at what works for the parties, and usually on those day-to-day, very specific parenting concerns.
And they're arbitrators as well. So if, you know, when they try to mediate the issue and they're not making any headway, then they make a decision and it's binding. So it's a form of arbitration in that sense.
And it's also important to note that most parenting coordinators won't actually see parties unless there's an agreement in place. Okay. So they need a starting point.
Yes. Okay, so that's parenting coordination, and let's talk about the last one, which is litigation. Do we even need to say anything about the litigation process? It is what it is. Litigation, you're in court. That's it.
Yeah, I find litigation is very adversarial for parties, especially because sometimes you might have a case, when you go to that case management judge, your case management judge is the judge that, I mean, depending on the court that you're in, may actually be the same judge, or it may vary from conference to conference, but you know, you might have that one judge that agrees with your position, and then you might have another judge that disagrees with your position. And then it makes it, and because of the cost that you're dishing out to it, it makes it so litigious. Mm-hmm. And sometimes it actually increases conflict. And
it does.
To be honest, I've never seen someone walk away incredibly happy after a conference. And, you know, the judges always say, if both parties are disappointed, you came to a good agreement.
Right. And I like to stay away from drafting those court materials right away, because the way we would frame the issues
sometimes don't sound the nicest.
Yes, we can't go back from it. So it's one thing if we're all sitting around the table, either having a collaborative team meeting or we're in a mediation setting. And I can say, well, Dad is usually late in picking up. Last week, he was late all 5 days that he had parenting time, and we can have, and it just, you know, and
it's her job.
It's not a pleasant thing to say, but it's so different from when you see it on paper. You read it several times, you interpret it. I can tell you many times I'm trying to write things as nicely as possible. Even the court forms themselves just give a whole different life to those words. And so the other party is just like, now it's like flames, everything's on fire. The other person has to, you know, counter with the 2 days you were late.
It could be the he said, she said, and it's messy. It's messy. And sometimes it inflates the problems. And you'll see that, as lawyers, we see that during the file as it's proceeding in litigation. You could see the contention. You could see the issues. It's not the most useful process if there's another way.
Yes, there's time. I'm glad you qualified it that way. There's another way, because there's times where the legal issues are so black and white.
Yes, it makes sense.
That, you know what? Let's not even dance around this. Let's just take it straight to court. Now, even having said that, even in cases where I know I'll be successful in court no matter what, there's the time, right? So when you still
try to do mediation, of course,
because of the time issues.
Exactly. And because it's a voluntary process, if the other party doesn't agree, then I mean, you're really left at, okay, we're at court now, and really there's no turning back. Unless, you guys come to an agreement. But if they're not open to that alternate dispute resolution method, then there's really no other process than to proceed to litigation.
But what I was even thinking was in terms of, say, a party where, let's say with spousal support, for example, it's very clear there's entitlement, the amounts are not complicated to come up with, and one party is just straight out obstinate. And I know, my clients may be asking for the low end, and I know if I went to court, like, no doubt I'm going to get the high end. And, this party is just saying there's no entitlement, right? So I know without a shadow of doubt, in some cases, it's so clear to me I will be successful, but I may still not go to court because justice for my client may come in 2 years. Think about it. I first cannot even bring a motion for this until there's a case conference.
Unless it's urgent.
It's
a higher threshold.
It's such a high threshold for urgency. So my client doesn't get any, we don't get in front of a judge for so many months. And even then, that particular judge can't order what I want. And maybe or maybe not, we don't bring a motion. And there's the settlement conference, the trial management conference.
It's the delay. It's never a consistent effort. Sometimes you have to leave it because if the other party is so obstinate, then, there's really no settlement there. So you're waiting for the next conference, then the next conference, and then, again, motion date. So it's a process.
Yeah. So if there's the opportunity to take that matter to mediation or arbitration, I would like to do that just because I can get the same result from an arbitrator in a much quicker time frame than I will from court. And with I know, Sherine, you had an experience that you shared with me recently where a client thought they had to go to litigation to get what they wanted, right?
Yeah, they were actually already amicable, and she had wondered specifically that she thought she actually had to go to litigation, specifically start an application to the court for her to have primary residence or primary care of the children, and then majority of the parenting time, and then decision-making aspect. I told her, no.
Yeah.
I'm like, that's a very common misconception. You can actually have all of the terms that you guys agree to, and that's kind of why negotiation is so important, all in a binding domestic contract, such as a separation agreement.
Exactly. So you can settle your dispute, not even, in this case, not a dispute. You can resolve issues that arise as a result of the separation, because when you separate, it's just part of cleaning house. Yeah. You have to organize stuff. There's things you have to do. So even if it's as simple as saying, well, we don't want to divide our property, we don't want to pay each other support, you still have to go through some process to articulate this agreement.
Well, we
and all
strongly
of that.
recommend that you do.
Yeah, we do. So, and litigation doesn't have to be the process.
Yep, you can have an all-encompassing agreement that is just as binding as a court order. So that's a common misconception as well.
And some people also come to me thinking mediation also is the only way, right? So when you have those that think court on the one end, and those that are a little bit more amicable are thinking, well, we have to go to mediation. And the number of times people have told me, we've agreed to joint parenting, and they tell me they've agreed on all the terms.
In mediation?
No.
They don't have a binding agreement?
No, they've agreed to all the terms on their own.
Oh, wow.
And they're thinking now they go to mediation. And I'm like, no, you don't have to. The idea of mediation is to help you guys get to this point, and you guys already did that yourself. So you don't need to go to mediation. The only thing you need to both do now is get independent legal advice and then articulate what you want in a separation agreement. And that's about it.
Thank you so much for listening to our podcast today on the different dispute resolution processes. Today you heard us talk about negotiation, mediation, arbitration, collaborative family law, parenting coordination, and litigation. Please keep in mind that you can actually resolve your family law matter with one of these processes or a combination of them. So thank you so much for tuning in.
And until next time, bye for now.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.